everyone. My name is Mary Jones. I serve as chair of the Marriage and Family Therapy Advisory Committee of the Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify their presence at this open meeting that's being conducted remotely by conference call and other electronic medium. Jardine Coleman.
I'm here.
Nicole Eitzen.
Here.
Chris Haben.
Here.
Marcy Lechtenberg.
Here.
And Heidi Vella.
Here.
And I note that the following BSRB staff members are also present. David Fye.
I am here, and Leslie Allen had a conflict this morning. She might be able to join us a little bit later.
Okay, perfect. Thank you. Next, David Fye will read a message about this meeting being held remotely.
Thank you. This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the advisory committee to address the advisory committee about its concerns, but the Kansas Open Meeting Act, or COMA, does not require advisory committees to provide public comment or answer questions from individuals. Individuals requesting to provide public comment could contact the executive director prior to the meeting by sending an email to david.fye@ks.gov. There will be no public comment at this meeting as no individuals have requested to provide public comment. Because we are conducting this public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Public access to this meeting is conducted by medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of COMA are not suspended, so we will be conducting this meeting pursuant to the COMA. On August 30th, 2023, we sent notice of the advisory committee meeting to all individuals who have requested notice of advisory committee meeting. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting material have been posted on the board's website and are available for review. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with the subject line request for the agenda, and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if we have any technical issues during the meeting, you may call the board office at 785-296-3240 or send an email to bsrb@ks.gov. A recording of the meeting will be available on the BSRB YouTube channel following the conclusion of the meeting by using the link to the meeting on the agenda. And the conference call line is active. I did check it before we got started, and there's no one currently on the line, but if I hear a beep, I will let you know.
Okay, thank you very much. Our first item of business will be the agenda approval. So if you would take a look at the agenda, and if there are any additions or changes, please let us know. If not, we'll take a motion to approve.
I move that we approve.
Thank you, Marcy. Is there a second?
I second.
Thanks, Nicole. All in favor, please say aye.
Aye.
Aye. Any opposed, same sign. Excellent. You did receive a separate email this morning, I believe, from the minutes of the last meeting. So we'll take a minute to review those and see if there's any comments or edits that need to be made. If not, I'll take a motion to approve.
I approve the minutes.
Thank you. Is there a second?
I'll second.
Thank you, Jardine. All those in favor say aye.
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 Any opposed, same sign. Great. I'll pause for just a minute and welcome officially Heidi to the meeting. I think it'd be nice just if we took a pause and each of us introduce ourselves a little bit, and then Heidi can share a little bit about herself. I'm Mary Jones. I'm chair of the Behavioral Sciences Regulatory Board, and I serve as the chair of the Marriage and Family Therapy Advisory Committee. My full-time job is the Mental Health Association of South Central Kansas in Wichita. So welcome. Who'd like to go next?
I can go. I know Heidi. Hi.
Oh,
Nice to see you here.
thanks, Jardine.
Good morning, Heidi. My name is Chris Haben. I am in the Kansas City area, actually in Overland Park, Kansas. I'm a program director for the Marriage and Family Therapy program at Friends University here in Kansas City.
I'll go next. Heidi, it's great to see you again. I'm still in Manhattan.
Hi, Heidi. I am Nicole Eitzen. I live in Wichita, but I work in Hutchinson at Horizons Mental Health Center. I'm the CCBHC program director there and provide clinical supervision to folks.
Thank you. My name's Heidi Vella. I got my master's at Kansas State University in 2014 and with marriage and family therapy. And then I worked at Pawnee Mental Health for 6 years doing therapy. And then in 2021, I left and started my own private practice. And I'm still doing that today. I also am an approved supervisor, although it's hard to compete with a free supervision provided by the community mental health center. So I would love to supervise more people, which is more than zero. And then, yeah, with my area of focus for clinical work is I'm pretty intense in family therapy. I'm one of the few providers I'm in Manhattan, one of the few providers that will do full family therapy in Manhattan. I also work with most ages. I'll work with as young as 18 months and up. I have a lot of skill working with under 5 and then also teenagers. And then I do have additional training in trauma. I do EMDR, but I wouldn't say that's like my focus. My focus would be definitely doing more of that family work and helping heal systems. So.
We are glad to have you. Thank you so much, Heidi.
Yeah, thanks.
Dave, did you want to?
Yeah, I was going to say, I was going to roll it into the next part of the agenda with my report. Yeah,
Go for it.
Happy to introduce myself to you as well. Heidi, it's nice to meet you in person by screen. We've talked a little bit on email in terms of you getting connected to the advisory committee, and really happy that you're willing to volunteer your time to serve, and looking forward to getting you to know you better. In my role as executive director for the Behavioral Sciences Regulatory Board, I try to oversee the operations of the agency here. We have now a 12-member staff here at the office, and we are what is considered by some states to be a composite agency. And so we oversee 7 different mental health professions and do the regulation, licensing, and then also investigations and complaints against practitioners. And then there's just a number of day-to-day activities that are involved with operating a state agency. And so, I'd be happy to help you get connected more and learn a little bit more about the agency. And then Leslie Allen, the assistant director, she's also a really great resource for you as well. She has been the assistant director and licensing manager of the agency for several years now, and she's held other roles over the years. She's been with the BSRB for over 20 years. And so Leslie is a great resource to you too. So don't hesitate to reach out to me or Leslie if you have any questions on your role as an advisory committee member.
Great, thank you.
And Dave, with that, I think you can go right into your report.
Okay, great. Well, thanks, Mary. So yeah, it's been a busy time, and at each of the advisory committee meetings, I do try to provide an update to each of the advisory committees in terms of BSRB operations, items of note, and then also some updates from board meetings, and then any other specific special updates. And so I'll start with some operations updates. Last meeting, and I think a little bit earlier this year, we talked about legislation going before the 2023 legislature, and the board and you as advisory committee members did a significant amount of work last year and really going through different concepts and proposing recommendations for the board. And the board really took an aggressive approach to trying to come to the legislature with a lot of solutions to resolve some workforce issues, while also making sure that we have good protection of the public. And we're really proud of the approach the board took. They requested a bill that I believe initially was about 70 pages long. Had many different items in it. And when that was heard by the different legislative committees, there were some changes. The legislature took out a few items, they added some items and made a couple changes, and added some new responsibilities for the agency in addition to the new license types and other things that were in the bill. So that bill did pass. It passed as sub for Senate Bill 131. And the bill had an effective date of July 1st, or really upon publication in the statute book. The publication in the statute book is a little tricky because the revisor's office does take a little bit of time to do that, but there were some items in there that we really wanted to get a jump start on. And so as we approach the beginning of the next fiscal year, We talked to the board and really asked to be able to put in a temporary regulation to be able to issue some of those licenses. But to do that, we needed authority to set certain amounts for fees. And so the board went ahead and approved some temporary regulations. We moved that through the process. And so since about July 1st, we've been able to move on a number of those different items. And then as of about August 15th, August 14th, we were able to really roll out any of the remaining items for that bill. So it's taken a lot of work behind the scenes. A lot of my staff members did a tremendous amount of work on forms, working with our vendor that hosts the licensing system. And we have been able to do a lot of those new items involved in the bill. And information on that was sent out to all licensees, I believe at the end of June. And then we posted another update on the website about the middle of August. But I thought I would just kind of briefly cover some of those items, just to let you know about those new items that are out there. So as far as temporary licenses, we are now able to issue those that last for 2 years for the marriage and family therapy profession. Some of those temporary licenses had lasted for 2 years for the psychologist and master's level psychologist prior to the changes in law. But the board was receptive to making that a 2-year temporary license, and that provides individuals more time to be able to work while taking the licensing examination. And in case they had any issue passing the examination, they would have more opportunities to take it again and pass it. And it also provides more security for employers who are employing individuals with a temporary license, because they know that regardless of the outcome on the examinations, they would be able to employ them for at least 2 years. And so really excited about that change. That was well received by the legislature. And so that's a positive change that we've been able to start as of July 1st. We've had some questions about if individuals who had an existing temporary license, would we be able to extend that for another year? And that we don't have the authority to do that. However, there is some language in the regulations and statutes that says if someone had an extreme situation, the exact language calls for an extenuating circumstance, but if they had an extenuating circumstance that was the reason for them needing an extension of their temporary license, they could request that kind of extension from the BSRB. And so I've received a few requests from individuals who've had health issues or other extreme reasons why they needed some more time. And I've been trying to be pretty flexible with that while still meeting the requirements and the regulation. And so we're able to do that in certain cases, but as of July 1st, those new temporary licenses have been 2 years instead of 1 year. The board also had requested a change to statute in terms of reciprocity for individuals seeking licensure. Previously, there was language that said if someone came from a jurisdiction with similar or essentially the same license requirements, they would be able to get licensed quickly. But if they came from a jurisdiction that had a similar scope of practice, they would need to have practiced in that jurisdiction for 48 of the last 54 months. And the board was supportive of reducing that time from 48 months down to 12 months. And so that is more in line with a change for other members seeking reciprocity that was passed in 2021. That was for military members and military spouses. And so really excited about the change made to the reciprocity law there. And that is effective as of July 1st of 2023. For individuals with clinical license, there are some additional requirements, and we have to make sure that individuals don't have a disciplinary record or other reasons why they wouldn't qualify for licensure. But being able to shorten that time frame has been helpful for individuals seeking licensure in Kansas after being licensed in another jurisdiction. Additionally, in addressing workforce, the licensed psychology profession previously had an item in their regulation that allowed individuals to request more time if they were approaching the expiration date of their license, and there was an unusual or extreme reason why they weren't able to complete their continuing education hours prior to the expiration of their license. And the board was receptive to providing a similar flexibility for the other professions under the board's jurisdiction. This would not be something that would apply to all individuals, but if there really was an extreme situation, someone had an extreme health situation or a big reason why they weren't able to complete their hours, they now have a process in law where they can request additional time to complete those hours. And if they are approved, then they will get up to 3 months to complete the remaining hours. But they have to demonstrate a plan to complete those hours and show extenuating circumstances for needing that. But we're hopeful that that will be a nice tool to have available for individuals who are coming to that situation who are having to make the decision, should I let my license expire, or should I, is that my only option? And now there is another option for those people to stay licensed. Similarly, in addressing workforce and sort of an outside the box approach, the board was looking at individuals who had previously been licensed who may want to become licensed again under the BSRB. Maybe they stepped away because of a health issue or wanting to start a family or one reason or another. There are individuals who've previously been licensed who may want to practice again. And under the existing rules before, basically to come back, you would need to pay essentially double the license fee and be able to have all of your continuing education hours before having your license fully reinstated. The board was receptive to putting into law 2 new things. One, if you have been out of your, if your license has been expired for at least a year, now you will be able, if you come back, it will be half the cost of what it was previously. It'll just be the regular renewal cost for you to reinstate your license. Additionally, if you have not completed all of the continuing education hours for your license to be permanently reinstated, there is a new optional 6-month temporary reinstatement license, which would allow individuals to work for a limited period of time under supervision for up to 6 months. And during that time period, they would be able to finish the remaining hours. And then once they're done, they could have their license permanently reinstated. So looking at different ways and thinking creatively in terms of workforce, helping people come back to the profession, helping people stay licensed, and then helping people become licensed more quickly. Additionally, for some of the other professions, there were some really helpful items. One, the behavior analyst statutes were a little bit different when they were initially put in. They lacked some of the disciplinary remedies available to the board when certain things occurred. The previous statute said that if someone had an infraction or disciplinary issue, the board could suspend their license or revoke their license, but the other professions allow things like a fine or conditions or things that might be more appropriate for a smaller violation. And so the language has now been changed in statute to be more similar to the other professions. Additionally, there was previously not authority for the BSRB to reinstate a behavior analyst license. So if a license expired, they would have to reapply all over again. Now the language has been added and the advisory committee for the behavior analyst can work on some regulatory language to establish that process. Additionally, there were some changes made in law for the licensed psychology profession. Previously, the standard for licensure was good moral character, but the more common standard is to have someone merit the public trust, which is more in line with the other professions, and so that has now been changed. Additionally, we had individuals who were seeking licensure as social workers from new programs that were not accredited by their national accrediting body, and maybe they were in the process of seeking that accreditation. If you do that, that process can take 3 to 3.5 years. So people were coming through those programs and they were in that window of time. And while there is regulations for how to look at those programs, those regulations currently require some classwork to be physically at the school, and for new online programs that pose an issue. And so the board looked at other states, found a good solution from Minnesota and modified it to match what Kansas could use. And so now if individuals apply for licensure from schools that are in that position, if they're in candidacy for accreditation, then we'll be able to issue a temporary license specifically to those people while their school is in candidacy for accreditation. And once their school becomes accredited by CSWE, we can give them a permanent license. So solving issues like that was really a good thing to have put in law. And then there's also creation of a new student temporary addiction counselor license. These would be for individuals who are seeking to finish coursework to become a licensed addiction counselor. And this would be a new type of license for someone who had about 60 hours, so they're well on their way to that degree. But it would be an agreement between the facility where they would work under supervision and also their school to be able to work under those types of arrangements while they're finishing the hours needed for their degree. And so this is something really positive, and we're putting this into place right now. Additionally, there was a creation of new community-based licenses. These are an alternative to traditional temporary licenses, but they are specifically available to individuals who are seeking to pass the licensure examination that have been offered employment in a handful of different types of facilities like community mental health centers or psychiatric residential treatment facilities, or other types of facilities named in law. And so these new 6 community-based licenses are available now and are available for people to apply for. There's also language that called for an expedited application review process, and it asked the board to go ahead and create that process. There's really no similar process to my knowledge in other states. And so we've worked with the board to develop language on that. And I think we have a pretty good model right now. And I think some specific language will be available for the board to look at the board's out-of-town planning meeting on October 23rd. And I think that's a pretty good summary of most of the items in that bill. But in addition to some of those items, there was some language put into the bill that established new timeframes for certain BSRB operating processes. And some of that has to do with sending out more correspondence to individuals when they apply for licensure. And so we've been putting that into effect and tracking it. And then also trying to make sure that we are making a decision on licensure within 30 days of having everything we need to have a complete application. And so we are putting some tracking processes into place to make sure we're meeting those timeframes. In all of these new license types and everything else, as you might imagine, there's a lot more work for the agency. And so we made a request to the legislature if we could have authority to hire 2 new licensing specialist positions, and the legislature did grant that for us. So after we got authority to do that on July 1st, we went ahead and did the interview process for those candidates. We looked at individuals outside the agency and some that were internal, and made the decision to hire 2 individuals for those positions. Those 2 individuals were internal hires here at the agency, individuals at other positions who wanted to take on more responsibility and challenge themselves, which was always really positive to see. However, that did open up some other vacancies, and so we had to have other rounds of interviews. And so now, as of maybe about 3 weeks ago, we are fully staffed, trying to plug people into the new roles. As you might imagine, with a small agency, there's lots of spinning plates, getting new technology for people, figuring out workstations. At the moment, we have temporary workstations set up in the actual boardroom itself. We are trying to modify one room to have a shared workstation with 2 employees who are working remotely a few days per week. If you hear some banging, there's people here who are actually physically working on the office next to me to get a new jack for some of the computer technology. So we are under construction, to put it best, but looking forward at moving forward in a lot of these really positive ways. And I'm excited about it too. I think it'll be really good, and it'll be nice to have ways to track some of this information and be able to report it back to the board. But it has definitely been busy. In terms of other responsibilities, the state has provided some direction for new processes. There was recently a governor's executive directive that established that all agencies would have a continuity of operations plan, COOP, and there are certain, it's not just to have one of those in place, because we do have one here at the agency, but it's really more of a structured concept that requires a lot of information and work to be done on behalf of agencies to make sure that individuals are listed for certain tasks, and that in case of an extreme situation, we would be able to set up quickly in a different location and things like that. And so we're working with representatives from the Department of Emergency Management to make sure that we have those things in place. But it should be a pretty good process, and we're currently working on that right now. In terms of some updates from some previous board meetings, I wanted to let you know the board did meet last month, September 11th. And one new item, the board did welcome a new board member, Jill Flessing, to the board. She is a new board member for addiction counseling. She has the spot previously held by Deb Stidham. And so happy to have Jill on the board for the addiction counseling. Additionally, the board discussed a couple of different items wanted to make you aware of. So one item that your advisory committee had previously discussed, the possible changes to clinical training plans and the requirement that changes would need to be submitted within 45 days. So the board has been discussing that item and whether an alternative approach or an alternative solution might be helpful. And so they did talk about that a little bit further at the last board meeting. And I think some of the advisory committees had been talking about adding some flexible language and maybe looking at ways in which the board could review more of those cases and not be held to the strict language in terms of denying a lot of those hours. Also balancing out from the licensing perspective, how can we provide clear guidance to individuals who have questions about the standards of what needs to be reported? And so I think I'll have a couple more comments about some of that discussion when we get to that item on the agenda for this meeting, but there's been a lot of good conversation on that topic. Additionally, there was conversation about individuals from other professions serving as supervisors under extenuating circumstances, and specifically the language for that is included in the professional counseling regulations in the marriage and family therapy profession regulations. And I know you talked about this item at your last meeting too, and then there'll be some further conversation of this later in the meeting. Additionally, the board is made aware of a change to federal law that has to do with being able to practice as a military member and military spouse. This was a change to the Service Members Civil Relief Act and portability of professional licenses for service members and their spouses. This is a recent change to federal law that a lot of states are trying to figure out how to implement and how exactly this will work. But essentially, I think the intent is that if military members and military spouses have a license in another state that has a similar scope of practice to what Kansas would allow, it creates an alternate to traditional licensure for them to be able to practice under sort of a recognition type approach. As I mentioned, we're trying to work through this because we have a license verification portal which provides information to the public about who's practicing in Kansas. And under this, I'm not sure that that would line up correctly because we wouldn't really be issuing them a license. And there's also questions about jurisdiction we would have over individuals if they're practicing here under that type of recognition. If the board, if they completed a violation of unprofessional conduct, we would be able to assess disciplinary remedies against them. And so we're still trying to work through some of those details, but that is something for the board to continue to look at and to work through. Additionally, the board had a couple more comments on putting out an RFP for an impaired provider process. And I've met with a couple board members and we've talked a little bit about an approach to an RFP for that. So that is something that the board will be moving forward on here this fall. And then in terms of other upcoming items, there is a board offsite planning meeting on October 23rd, 2023. That is the meeting that the board generally tries to hold an all-day planning meeting once a year and tries to get in person to do that. This year, that meeting will be in Wichita at the Seasons venue at Watson Park, and information on that has been put out. It's on the BSRB website as well. That will be on Monday, October 23rd. It is an open meeting, even though it is in Wichita, and it should go from about 9 a.m. until 4 p.m. Based on the logistics of using a different venue. That meeting is not going to be broadcast on the BSRB YouTube channel, but any individuals who wish to attend in person are definitely able to do so and welcome to do so. At that meeting, some of the topics that the board may be discussing has to do with the length of time for supervised practice when individuals are creating hours towards a clinical training plan. Previously, for many of the professions, you had to get about 4,000 hours, and that number was reduced down to 3,000 recently. When it was 4,000, the minimum length of time was 2 years. And the question has been asked, well, if the time frame was reduced, could it be proportional to the amount of hours that were reduced? So if it was 2 years for 4,000, should the minimum time now be 18 months instead of 2 years? And one item that I've been looking into that may play a factor in that is there was a recent change to some of the Medicare laws, and it has to do with reimbursement specifically for professional counselors and marriage and family therapists. And I reached out to KDHE to try to see if I can get a better understanding of that, and they are looking into it and will get back to me. But some of the language that talks about those reimbursements talks about a 2-year period where individuals are practicing. And it appears to seem to talk about that time frame that individuals will be getting those postgraduate hours. So I wouldn't want to inadvertently encourage the board to make a logical change down to 18 months if it could interfere with something like reimbursements. Reimbursements are usually outside of the BSRB purview. They're usually handled by agencies like KDHE or KDAS, the Department for Age and Disability Services. But when we're looking at possible changes to the requirements for law, we have to be mindful of those things too to make sure we don't do something that would have inadvertent consequences. So to be determined, but I'm still trying to gather some information back from KDHE on that point. Additionally, the board talked about wanting to discuss the current requirement of needing 1 hour of supervision for every 15 hours of direct client contact for individuals pursuing a clinical license. So good discussions right now that we're having as far as requirements for clinical licensure, and good for us to review all of the items in our regulations to make sure they're still letting the board reach the objectives that the board is seeking to do, and make sure that if things need to be updated or modernized, that we do that. So, and then the only other updates that I wanted to provide you on is next week we have a couple of unique and I think really positive meetings. Many years ago, the BSRB had forums for educators from different colleges and universities. And for several years, we have not had those types of meetings, but there's an interest in renewing those. And there's definitely changes with the new legislation and other items. And so we have scheduled a optional informational forum next week on Tuesday, October 17th. The one on Tuesday will be an hour-long informational forum for educators to kind of talk about some of the changes in law, and then to answer any questions individuals from different colleges and universities have questions. And then the following day, on Wednesday, October 18th, we have a similar informational forum, but that one is one that the BSRB has, to my knowledge, never done before, and it's specifically for individuals who are employers of a lot of individuals licensed by the BSRB. So we're really trying to reach out and be proactive and having conversations with different groups of individuals to make sure that they know about the changes in law and the changes that we're pursuing in regulations as well. And so looking forward to those two meetings. Those are not official meetings of the board. They're more for informational purposes. And so those will not be broadcast on the BSRB YouTube channel. But we've tried to extend invitations to people. And for that employer list, we have never held a meeting quite like that before. So we did our best to try to put out that information. And we hope this will not be the only time that we have a similar meeting like this. And so we're hoping to build a contact group for that and then build onto it for a future event, maybe sometime next year. And the same thing for the educator forum. We had a list of educators and we attempted to reach out to schools, but I'm sure that list needs to be updated, and we've tried to make additions. But for any individuals who weren't able to reach this time, we'll try to catch them next year when we have a similar event. So with that, I will end my report and see if there's any questions.
What was the time of the educator meeting on Tuesday?
That is going to be from 1 p.m. until 2 p.m.
Thank you.
Sure. And I have had a few people respond back to me late yesterday requesting some of that information. And so I will be following up with individuals to make sure that they get them. And I've requested that some of the individuals that received the invitation to respond back to me by a certain date, but I'll be pretty flexible with that if individuals reach out to me. And this will be kind of a unique experience. And so looking forward to talking to those individuals and sharing information, and then also collecting some comments and questions if they do have questions. And so we can share them with the board at the October 23rd meeting.
Any other questions for Dave? Thank you so much. It's always a lot of information you're giving us. A lot happens in the 2 months between meetings here. The next item on our agenda is a little bit of an update of the AMFTRB conference that Dave and I were able to attend in Salt Lake this last month. And just to give sort of some updates and things that are being discussed at that conference and the types of things we can be concerned about here, which is, just want to say again, thank you, Dave, for allowing me to go to that, because it was really a great experience, and how to listen to the types of things that are going on right now. You know, there is a portion of that meeting that talks about the exam itself, and that really is sort of the less part of my impression. The one thing I really wanted to share with this group is the work being done around how to make licensure across jurisdictions happen. So there's a lot of discussion around, you know, we've sort of heard this coming with all the compacts, and the BSRB has been a willing partner in the compacts that are already happening, but it's I think the comment was now that Medicare is a done deal, they can focus a lot of their efforts in looking at how we can move licensure in a different level. And so there were a few strategies discussed in that, but I do think that's high on the priority list of the next several years' work to make sure that marriage and family therapists can get licensed across jurisdictions. So good discussion and nice panels around that. The other piece that was really interesting was our own colleague, Sandra Stith, presented with one of her colleagues at K-State about how we should be dealing with violence and homicide, specifically in couples. So there's some emerging research and trends. I thought it was really interesting. So however we can figure out to best communicate that to our own colleagues here, I think is really important. We had some great discussions and opportunities to really process what does that mean for us as regulatory boards. So, even though we're getting this sort of clinical perspective, our charge is to look at it from a regulatory board perspective, and if there was any discussion in there. And I think that's where it became really challenging for us. A piece of that would be the TerraSoft laws that Kansas doesn't have, but is there something in there that we can do not only to, one, ensure that licensees do appropriate risk and assessment, or is there a role for us in enacting some type of formality when it comes to that? So that was really interesting. I know Dave will get his impressions too, but those were, I think, from my perspective, the two real standout things that I was excited about.
Yeah, and Mary, I wanted to thank you again for attending that conference. As a composite agency, we have opportunities to attend some of the National Association meetings, but in the past, this meeting usually had fallen when the agency's budget was scheduled to be turned in, which is not a very great time to be out of state. And but this year, because of a couple of changes, it was a little bit later, and things fell in line real nice. And so this was the first opportunity that I've had to attend this conference, and I know Mary, it was your first time attending that conference as well. And yeah, I thought it was really interesting, and it was really interesting to focus on some of the different items they talked about. One item, that there has been a little conversation about is, are there any plans for a multi-state compact specifically for marriage and family therapists? And it sounds like that there is interest in people having portability of license and being able to help individuals across state lines, but at least in the very near future, it did not sound to me like there are concrete plans for a multi-state compact. That doesn't mean that it can never happen, but at least from what I heard in some of the discussions at the conference, it sounds like that's not something that is on the immediate radar. But there are conversations about how individuals can practice in other jurisdictions and help individuals. And one of the topics they talked about was something called universal licensure recognition. And so that is something that we've had sort of as a modified version in Kansas. I mentioned that military bill that passed back in 2021. And so they never called that universal licensure when it came before the legislature, but in talking about universal licensure, some of the description seems to be similar. And part of that is looking at individuals who've had a license in another jurisdiction with a similar scope of practice and have practiced there for a year. The bill that passed in Kansas was specifically targeted to military members, military spouses, and then individuals that reside in Kansas. But with the recent change to the reciprocity statute that the board was supportive and requested, I think that's more in line with sort of individuals seeking licensure under traditional universal licensure statutes. And so that'll be something interesting to look at. There was also some conversation about portability of licensure and what was important to people about portability. They did some surveys and some polls of individuals, and sounded like 71%, I think, were interested in a multi-state license at some point. 44% were in favor of expanding portability over a licensure compact. So at least in terms of the two, there is still some interest in a multi-state license one way or another. There was some information on what individuals would want if they were able to use a license in other jurisdictions. And it seems like the majority, 88%, would want to be able to treat clients when the clients move out of state rather than, what was more common. When we talk about license portability, I think what comes to mind most of the time is people moving from state to state as a licensee. But I think in a lot of situations here that was discussed about, well, what if I'm treating someone and they go on vacation or, they go to another place? Can I continue to help them? And right now, you have to be licensed in any jurisdiction in which the client is located. And some of those jurisdictions require you not only to be licensed where the client is located, but also where you are physically located as well. So, but it was interesting to hear some of the discussions about that. There was also some discussion about licensing examinations and jurisprudence examinations. There was some conversation that if somebody is seeking to practice in a lot of different states and they have 11 licenses and they're seeking to have a 12th, how likely is it that they really know the laws of those jurisdictions? And, from our perspective, unprofessional conduct is really important to make sure that people are providing services in a way that is safe for our public protection mission. And so it does beg the question, if individuals are out there providing services, are they really aware of everything? So some jurisdictions are looking at a jurisprudence examination. That would be something that would need to be developed. It would have to be, defensible, and it would probably take some time and money to do that, but that is something interesting to look at. I've heard that from some of the other association meetings as well. In terms of other topics, they talked about postgraduate supervision for licensure. That is a topic that, unfortunately, there's not a great deal of standardization state to state. In terms of Kansas, we're a little unique in that we have 2 permanent tiers of licensure. And so some of the discussion on supervision and other things didn't seem like it always fit completely with our system. It sounds like Kansas is one of 2 states, I think with Ohio, that have 2 tiers of permanent licensure, whereas a lot of other states will call those individuals below the clinical level provisional licensure or temporary licensure, and we have temporary licensure as well. So definitions get a little confusing on some of that. But in terms of what some of the states require, I think, in terms of our hours, I don't think we're too far off what a lot of the other states require. In terms of regulatory trends concerning complaints, it sounds like a lot of states have had complaints that have dealt with things like supervision, others in terms of social media and telehealth. And right now, the board and the advisory committees are discussing unprofessional conduct, regulation changes. Given the time constraints, that'll probably be talked about at the next meeting in December, and hopefully the advisory committee can finalize changes to the recommendations at that time. And but there were a lot of good comments. I do know that there has been sort of a discussion in other professions, like the social work profession, concerning passage rates by different groups. I know there has been some questions about, are other professions going to be sharing information on passage rates by demographic group? That was a question that was asked, and what I can say is that that information is not available. So we don't have anything for the marriage and family therapy profession, but we will continue to monitor that. If there are reports that are made public that talk about passage rates by different groups, we'll definitely share that with you. But that question was asked, and unfortunately that information is not available to be shared at this time. So, but it was a great conference. We learned a lot of good information. Definitely were able to connect with other states and build connections to be able to get information from them in the future. So thanks again, Mary, for attending that, and looking forward to attending that on a regular basis going forward, as long as other conflicts don't prohibit us from doing that. But yeah, very good conference, a lot of good information.
Any questions or comments from advisory members? Great, okay. Well, the next item of the agenda is our annual training and training for new members of the advisory committee. So Dave's going to spend, it's probably going to take about an hour or so to get through all the training pieces. So we will give that back over to you, Dave. And it does look like Leslie Allen joined, if you hadn't noticed that. So she's not on camera, but I can see that she's on. So Dave, we'll let you take it from here.
Okay, thanks, Mary. And I'll go ahead and share my screen. I've got a presentation here pulled up. Okay, And you should be able to see my screen here. This is a large PowerPoint. It is a little bit too big to be sent out, so it is posted on the BSRB website if you want to go back and reference it in the future. But I think it provides some good information about the agency and then also your role as an advisory committee member. So go ahead and take notes, and if you do have questions afterwards, we can try to handle those, or if you want to send me any emails with questions afterwards, happy to help you with your questions too. So. But first, just kind of to frame this discussion, the mission of the BSRB, in accordance with the intent of the Kansas legislature, to protect and serve consumers of services offered by BSRB licensees through the issuance of licenses, resolution of complaints, and the creation of appropriate regulations, accomplished through efficiency, fairness, and respect to all those involved. Some of the history of the BSRB is that we were created in 1980 by the Kansas legislature when they took the existing Board of Psychology examiners and social work examiners and combined them, and as other professions have joined over the years, they've been added under the BSRB. Now we oversee licensure of not only the social workers and psychologists, but also professional counselors, marriage and family therapists, marriage and master's level psychologists, addiction counselors, and behavior analysts. I mentioned earlier, we're considered a composite board in some states. And so rather than have a separate board for psychologists, social workers, et cetera, we have one board composed of professional members and public members, and the combination of those are why we call it a composite. Some of the benefits of having a composite board is that we are able to save a significant amount of operational expenditures by sharing resources and utilizing licensing and investigative staff for similar subject areas. One way to help understand our existence versus an association is that we're created by the legislature. We exist to protect consumers, and we are governed by statutes and regulations, whereas an association exists to enhance the profession and is frequently created by members of that profession. Currently, we have 12 staff members, myself, Leslie Allen, the Assistant Director and Licensing Manager, licensing specialists, investigators, and also clerical employees. In terms of our operations, we are a fee-funded agency, so we do not receive any funding directly from the State General Fund. But by statute, we contribute 10% of all of our revenue up to $100,000 per year back to the state, and that helps fund state operations. Our revenue is primarily from license fees. Our annual budget is a little over 1.1 million. And as a small agency, we contract with and have agreements with many other agencies, such as our licensing vendor, legal staff, et cetera. In terms of the board specifically, all board members are appointed by the governor. They serve one 4-year term and may be reappointed for a second term, allowing for service on the board a maximum of 8 consecutive years. The board is composed of the following, which are identified specifically in statute: 2 psychologists, 2 social workers, a marriage and family therapist, a professional counselor, an addiction counselor, and a master's level psychologist, as well as 4 public members. There's 2 basic functions of the BSRB: licensing and investigation of complaints or discipline. Currently, there's about 15,155 active permanent licenses under the board, and those are the 7 professions that I mentioned. Every full board meeting, we provide a breakout to the board in terms of each of the different levels of licensing, as well as the grouped by profession as well. And so this kind of shows you some of the breakout in terms of how many individuals are licensed. For the marriage and family therapy profession, currently it is about 300 individuals at the non-clinical permanent license, and then almost 800 individuals at the independent clinical license for marriage and family therapy. In last fiscal year, which was fiscal year 2023, state fiscal years run from July 1st through June 30th, we issued 1,586 permanent licenses. These are new licenses, and 433 temporary licenses, 66 out-of-state temporary permits. And then of those 1,586 permanent licenses, 1,124 were by initial license, and then about 1/3 of the amount, 462, were through reciprocity. In terms of renewals, last year we processed 5,789 license renewals. And as part of the license renewal process, 10% of all applicants are audited to ensure they've met the continuing education requirements. Last fiscal year, we audited 587 individuals. Since July of 2015, the number of permanent licensees has increased by 24.7%, from 12,152 to 15,155. And I've looked at some of the demographic information for the state of Kansas. I believe over that time period, The population growth in the state of Kansas has increased by between 1% and 2%. So I think that's a tremendously positive thing to note, that over that same time span, even though the population of Kansas has risen by a small amount, the number of individuals licensed to practice and providing services to Kansas has increased dramatically by almost 25% over that time span. And the professions with the largest increases are professional counseling, social work, and also the behavior analyst profession. In terms of investigation and discipline, as a public protection agency, the BSRB investigates complaints against practitioners under the authority of the board. The agency has administrative authority over practitioners, but this process does not take the place of criminal proceedings or civil proceedings. So while we do receive complaints, if something does seem to be more of a criminal matter, we always indicate to the person that we don't take the place of that, so that may be better for them to contact legal authorities. And also we let them know that our process is not the same as a civil proceeding. So they are not a party to this. If they provide a complaint, we will investigate it, and then it's between them, acting on behalf of the state of Kansas concerning their license, and then that person as a licensee. But if they want to pursue other matters involving civil litigation, that's beyond our authority. In terms of complaints, last fiscal year, we received 200 complaints. We also call them reports of alleged violation against practitioners. For comparison, practitioners received 205 complaints the previous year, 130 complaints the year before that, 199 in 2020, and 201 in 2019. And if you're curious why numbers dropped so much in 2021, that was during a time period that was part of the initial stages of the pandemic. And there's lots of theories for why complaints decreased during that time period. But what I can tell you is that that drop is pretty consistent when we talk to other states. And part of this may be that individuals weren't receiving the same amount of services because individuals were trying to shift to telehealth and some were not able to do that, or maybe did not desire to do that. Other individuals maybe were unsure of what the appropriate standards were for telehealth because they were happy to be getting services one way or another. It was a very unusual time period. And so, but what I can tell you, like I said, the dip that year is pretty consistent when we look at other states. As far as the investigative process, complaints are reviewed to determine whether the BSRB has jurisdiction over the issue and whether the matter involves a potential violation of the statutes and regulations for the profession. There's a subset of the board that serve as a standing subcommittee for the review of complaints, and it's the Complaint Review Committee. Common violations that we see when individuals are have a violation: falsifying continuing education requirements. This is an audit violation. When individuals apply for licensure, they have to do an attestation that says they have completed all of their hours at the time that they are renewing their license. And unfortunately, some individuals have not done that, but make the attestation anyway. We also see individuals practicing without a license or practicing with an expired license. Some individuals have a dual relationship, which involves conflicts of interest. Some individuals make sexual advances towards or engage in physical intimacies with the client. We see individuals that refuse to report termination or suspension to the board in a timely manner, and those do need to be reported if they are for specific reasons. Confidentiality violations in general, and then other practice issues, performing services inconsistent with one's education or accepted professional standards. One of the functions that we perform on behalf of the board here at the office has to do with outreach. So myself and also the Assistant Director and Licensing Manager for the agency, we speak to groups of students and we provide information on licensing and disciplinary matters to provide a proactive approach to assist individuals before they become licensed. Last fiscal year, we had 16 presentations that were provided to groups of students or at other opportunities. I spoke to representatives at a forum for the Kansas Health Institute to talk a little bit about some changes in law, and there's some other opportunities as well. Also, in terms of outreach, back in January 2021, during some of the much earlier stages of the pandemic, we launched a YouTube channel as a way to have more secure board meetings and advisory committee meetings and provide more accessibility to the information that was being discussed by the board and the advisory committee. And so since that point, we've had about 124 board meetings or advisory committee meetings streamed live or uploaded, and those have been viewed over 4,000 times. And so I have the address listed here, but if you go to YouTube and type in KS BSRB, we're the first link there. So we will continue to broadcast meetings as long as we are able to do so, but really happy with that. We've received a lot of positive feedback from members of the public, and then also individuals from other states that are curious about moving in this direction. On our website, ksbsrb.ks.gov, we have a lot of good resources and tools. We have copies of each of the statutes and regulations for the board linked here. The statutes are actually from the Revisor of Statutes page, and the regulations linked to the Secretary of State's website, but you can access them directly through our website. There's also information about forums. There's frequently asked questions and other resources there. So it's a good place to visit to become familiar with your role and responsibility as an advisory committee member. And then just some of the features on the website: portal to renew a license, copies of forms and other applicant materials, statutes and regulations, proposed changes to statutes and regulations, complaint or report of alleged violation forms, disciplinary orders when individuals have a public violation and an order of discipline, and information on board and advisory committee meetings. During the introductory information, I mentioned the materials for this meeting are posted on the website, and those are available for any past meetings too, so individuals can go back and view the meetings on YouTube and follow along with the materials that are posted. Now we're going to shift and talk about some training specifically for board members, but you as advisory committee members, I think it's important for you to hear this information too, because it does frame your role as an advisory committee member.
Can I interrupt and ask a question?
Yes.
If I was reading the numbers right, and I might have been confusing professional or counselors with psychologists, but it looked to me like there were, I don't know, maybe 800 licensed psychologists. I could be wrong about that. If that's correct, there's a part of me that's wondering, why do they have 2 members on the board? I could see maybe why social work does, but why do they have more members representing that profession on the board than other disciplines?
Well, so that's the statute. So it's up to the legislature to establish who specifically serves on the board. I think there's a little over 1,000 licensed psychologists currently that are licensed in Kansas, but how it initially was established is the BSRB was formed when the licensed psychologists and social workers were put together. And so I imagine at that time, they probably put 2 and 2 together with maybe public members as well. And then over the years, as they added more professions, they probably added 1 for the new professions that were being added. That was not the case when the behavior analysts were added, but for the other professions, I think that's what happened. They added a member from those professions when they were added.
Okay, so there's 1,000 psychologists, and how many MFTs were there? I don't remember.
There's roughly, I think, 800 at the clinical level and about 300 at the non-clinical level.
So it's about the same amount, right?
Yes.
Yeah.
And I think there's been some discussion about, the membership on the board. One thing to remember too is it's not a proportional board, and it has to do with the nature of the BSRB. We're not an advocacy group. We're here for public protection. So it's important to make sure that we have representation from members of those professions, so they can speak to the intricacies and some of the public protection responsibilities. But it's not really formed to be representative of how many licensees are in different groups.
Okay.
But I'll go ahead and go back. You should have received about 3 handouts in your materials. There's one that talks about expectations of board members. There's also one about the advisory committee specifically, and then one that talks about public attendees at meetings. So in terms of the expectations of board members, this was a policy the board members adopted roughly about 10, 12 years ago, I believe. And then it's been updated, and it was just recently, there were some significant updates that were made to kind of split out the advisory committee policy as a separate policy. But it does kind of create a framework of understanding how the advisory committee fits within the overall responsibilities of the board. And it does state that insofar as the expectations of the board members conflict with or limits any federal or state statute or regulation, the statute or regulation controls. And so that basically just kind of says that in terms of the hierarchy, if there's a conflict, we look to the statutes, which are law, and then we look to the regulations, which need to have authority in statute, and then policies would fall after that. And the expectations of the board members document, that is a policy document. So if there's any conflict between the statutes or regulations, we would go with the statutes or regulations. In terms of the guiding principles, in that document, it does indicate that persons in Kansas shall expect that licensed mental health providers are qualified, competent, and professional, and persons regulated by the BSRB shall expect equitable and fair treatment in relation to licensing activities, disciplinary processes, and administrative regulations. The BSRB shall provide all services in a manner that is timely, cost-efficient, courteous, and competent, and the BSRB shall be guided by and led by ethical principles, clear policies, progressive thinking, and strategic decision-making, and the BSRB shall respect the dignity and worth of all individuals. In terms of services provided by the agency, we process license applications and license renewals in a timely manner, take disciplinary action when appropriate, provide timely information to the public, and maintain rules and regulations and statutes. In that document, there is a code of conduct which talks to integrity, and it talks about board members should have no criminal or professional misconduct record nor commit acts that would lead to investigations or complaints. A board member of the BSRB possesses sound moral principles, upright, honest, and sincere. A board member of the BSRB has courage of convictions to withstand pressures to be swayed from the public protection agenda. And a board member of the BSRB should be honest about personal agendas and leave them outside the boardroom. A board member of the BSRB should reveal any actual or perceived conflicts of interest and appropriately recuse themselves from decisions or actions in those areas of interest. A board member of the BSRB should not represent their personal opinions as that of the board. And a board member of the BSRB should be limited to one unexcused absence a year. In terms of conflicts of interest, a board member of the BSRB should guard against conflicts of interest. Under compliance, common components of conflicts of interest policies include, but are not limited to, some or all the following. A board member of the BSRB should have no personal financial benefit as a result of service to the BSRB, except subsistence and mileage. A board member of the BSRB who may have a conflict of interest according to stated criteria should refrain from voting on the matter. A member of the BSRB should disclose any relationship with any other agency or individual involved with the BSRB and be excluded from matters involving such a conflict. A board member of the BSRB serving as part of an organization working in any way with the BSRB should inform the board chair. And we do get questions on that item from time to time. Given the different groups that you volunteer for in the state of Kansas and your other memberships, we do understand that most people serving on the board or the advisory committees are likely to be members of other associations. And it really comes down to, are you part of leadership for that organization? And would your role as a member of that organization interfere with your role and responsibilities as that of the BSRB? And so we ask board members to go ahead and take those things into consideration and making sure that they can faithfully discharge their duties independent of other associations. Under item E, it says the board member of the BSRB should not accept any gifts or promotional items received as part of their affiliation with the agency for personal use. And a board member of the BSRB should not use the agency's name or agency information for personal gain. Under confidentiality, it talks about the board discussions involving any of the following matters shall remain confidential unless the board expressly agrees to the contrary. So any discussion that occurs during an executive session and any discussion concerning actual or potential litigation. So concerning executive sessions, that is an official formal process, and you will know if we go into executive session because there will be an official motion, there will be a vote, and then it will be outside of the broadcast. Usually when we do those in board meetings, we have a separate conference call specifically for those sessions with executive sessions. So don't worry about anything potentially being an executive session without you knowing it. It will be very clear. In terms of the board chair authority, the expectations of board members document does establish that the board chair presides at all meetings, appoints members to the advisory committee, appoints members to the CRC, and appoints members to other ad hoc committees. The vice chair discharges the duties of the chair in his or her absence, disability, resignation, or death. And then in the event of the executive director is unable to perform the duties of the office, the BSRB may request an interim director. And if the BSRB is unable to meet immediately, the board chair will seek an interim director until the board can meet. It also outlines the relationship between the executive director and the board. In terms of the organizational structure, the executive director will communicate any personnel matters that should be addressed by the board to the chair of the board. The chair of the board will present these board-related issues to the board, and the executive director will communicate with the staff, the board wishes, intentions, policies, etc. And that is done here with monthly staff meetings. In terms of the delegation to the executive director shall be the administrative head of the organization, serving at all times under the board. The executive director is responsible for implementing and executing the policies and activities approved by the board. He shall assist in the development of the overall program and shall recommend policies and activities for consideration by the board. Also, the executive director shall have authority to employ, eliminate, and fix the duties and salaries of other employees or independent contractors of the organization, subject to the policies, regulations, and limitations approved by the state of Kansas. And just to let you know, if anyone does get hired here, the individual themselves and also the amount have to be approved by the governor's office. So there is a check in terms of that authority. And then in terms of executive expectations, it says here the executive director will keep the board advised of BSRB activities by issuing a report to the board at each full board meeting, which summarizes pertinent information. The executive director prepares an agenda with the board meeting in consultation with the board chair. And the executive director prepares an agenda in consultation with the board chair for the annual board retreat or the out-of-town planning meeting, which should allow for issues before the board that need in-depth consideration. And then there's information here as far as monitoring the executive director's performance. The board shall, when necessary, utilize executive session to discuss issues concerning the executive director. The board shall also formally evaluate the performance of the executive director each calendar year and on an annual basis thereafter, with emphasis on whether set outcomes are attained. And I provide a performance review for all of my staff, and the board provides one for me separately. And now we're going to switch to a separate document. You have about a 2-page document, which is called the Advisory Committee Policy. And that document does state that the advisory committees are created and assigned to assist the work of the board. So the board does use those advisory committees as 7 standing committees, one for each of the 7 professions regulated by the board. And as a reference, the advisory committee policy is posted on the board's website. And then as of just a little bit ago, there were 53 individuals who are non-board members who are volunteering to serve on each of the advisory committees, or in total. In terms of the purpose of the advisory committee is the creation of the board, has the purpose of supporting the board in carrying out its mission to protect the public. Members serve at the pleasure of the board. Actions pertaining to informing, licensing, and disciplining of those persons regulated by the board are the method for accomplishing this mission. An advisory committee fulfills its purpose by addressing issues referred to it by the board through the advisory committee chair or the executive director. A committee may suggest issues that believes the board should consider by referring those through the chair of the advisory committee. The advisory committee has 3 different options for the processes. So when an advisory committee refers a recommendation back to the board can take 3 different steps. Can either agree the issue needs to be addressed at the board level, agree the issue should be addressed and refer the matter to the appropriate person or committee for additional information, review, or analysis, which will then be brought back before the board, or decide not to address the issue. Concerning the chair of the advisory committee, chairs will be members of the board. If the profession is represented on the board, the chair of the advisory committee will be the board member licensed by in the discipline of the committee and appointed by the governor to represent that discipline on the board. And the other board members appointed by the governor to represent that discipline on the board will serve as a member of that advisory committee. There's also a public member of the board who's a member of each advisory committee. And there will be a minimum of 3 and a maximum of 10 additional members that are appointed to the advisory committees. The executive director is a non-voting ex officio member. The assistant director and licensing manager is encouraged to attend, and legal counsel representing the board should attend meetings when their attendance is requested. In terms of the structure of the committees, terms for the advisory committees are 2 years, and they are appointed by the chair of the BSRB, and they can serve up to 4 terms total. Appointments to the committee should be staggered to avoid having too many members of the advisory committee reach their maximum length of service at the same time. So one service that I provide on behalf of the advisory committees is to ensure that we are following this. Every spring, I will be reaching out to members of the advisory committee to see if individuals who are coming up on their 2-year terms would be interested in seeking reappointment. And then for anyone who would be seeking reappointment, I will be in touch with the chair of the board to see if those individuals should be reappointed for another term on the board. And then there's some really—
Can I ask a question quick?
Sure.
Who is on this advisory board? Who's the chair and the member that serves on the BSRB board?
That is Mary Jones.
Oh, okay, great. I wondered if it was you, but I wasn't sure. Thank you.
Sure. Yeah, and the public member of the board is Jim Kilmartin. He's not here today, but Mary serves as chair of the board, but she is also the board member for Marriage and Family Therapy. So that is why she is chair of this advisory committee.
Okay, great. Thank you so much.
There's some language in the advisory committee that may help to kind of tie things together. The language in that committee, advisory committee policy states that the policies and procedures under which the BSRB board members are expected to operate will also apply to the advisory committee members. And so the reason I have that language bolded and italicized here is because I think it's really important. When you hear about the language and the expectations of the board members document, it talks a little bit about conflicts of interest. It talks about making sure that individuals are avoiding conduct that would lead to complaints or investigations or violations. And so it's just important to know that even though that document is specific to the board members and outlines some of their expectations, this language here in the advisory committee basically says that the policies and procedures which operate for board members really should be expected to operate for advisory committee members as well. Now, some of these are not going to match in terms of, membership on the board itself or things like that. But in general, I think when you're looking at your role as an advisory committee member, I would hold yourself to the same standards as much as possible. In terms of selection of advisory committee members, members of the committee may be nominated by anyone, including the public. Committee members of professional organizations, either through the discipline's own or others, or through self-nomination. In reviewing nominations, the committee should work to ensure there is diverse representation, including but not limited to geographic setting, gender, culture, and ethnicity. Members should provide representation of the levels of licensing for that discipline, and those members should be selected from among public and private practitioners and educators. The committee as a whole discusses nominations and reaches a recommendation on new members. The nominee's resume, a letter stating the reasons why he or she desires to be appointed, and a copy of the board's mission and goals to which the nominee has indicated agreement are reviewed. The chair of the committee will submit the committee's recommendation for new members to the BSRB board chair. The chair will review the recommendations and may request additional input before making a decision, which is announced at a board meeting. And then after the appointment has been approved the executive director will inform the advisory committee appointee by letter or email. And the executive director will assist the new member by providing information, which will help orient the member to the board and advisory committee's role and function. In terms of guidelines for attendees at meetings, that's the third document you received in your packet as far as training material. And as we have been broadcasting meetings on the BSRB YouTube channel, and we have more individuals observing the meetings, just for reference, back when there were in-person meetings only, from what I understood, over the course of a year, there might be 10 total public attendees at meetings. And now we have over 1,000 individuals, probably close to about 1,500 that are watching our meetings every year. And so that's really an increase in the number of people that are following, which is great. It does lead to some additional questions, and sometimes individuals want to provide public comment at meetings. And so we developed a document to kind of outline that process a little bit better and have individuals kind of get a more clear understanding of what items would be important for the meetings and which ones would be under the purview of the advisory committees and the role that they serve. So that policy does clarify that public comment is not entitled to individuals, but it may be approved. And it outlines the processes that should be followed during comments to the board or advisory committees and topics relevant for public comment to the board and advisory committees. It also clarifies that the board wants to receive valid complaints against practitioners and provides information on how those complaints are to be submitted, but informs potential attendees that certain matters concerning specific licensees will be considered in a closed, standardized process to ensure fairness to members of the public as well as licensees. And now we're going to take a detour and talk a little bit about broad responsibilities for board members and advisory committee members. This goes into a little bit more of the law and talks about topics such as the Kansas Open Meeting Law or the Kansas Open Meetings Act, the Kansas Open Records Act, the Kansas Administrative Procedures Act, and then just general responsibilities as board members and advisory committee members. So in terms of professional licensing boards generally, the state of Kansas regulates many professions. Each of the professions is regulated by a licensing board or commission that was created by the Kansas legislature for the purpose of ensuring that licensed professionals are competent and do not pose a risk to the public. A professional licensing board is created by enabling legislation, which establishes the board's form, mission, powers, functions, tools of implementation, and enforcement abilities. A board is considered to be a creature of statute meaning a board's power is dependent upon its authorizing statutes, and therefore any exercise of authority claimed by a board must come from those statutes, either explicitly or necessarily implied. A board may administer, implement, or enforce only those statutes. If those statutes are silent on a particular action, the board lacks authority to take such action. Simply put, a board can do only what the Kansas statutes say it can do. Besides statutes specific to a board's authority is limited by constitutional equal protection and due process rights, which are prohibiting a board from acting in a manner which results in disparate or inconsistent treatment of persons similarly situated, from adopting different standards for similar situations, or otherwise acting arbitrarily, capriciously, or vindictively. For example, a licensing board may not impose more severe discipline on male licensees solely because of their gender, or a licensing board may not revoke a license simply because the board is not like that particular licensee. Other constitutional guarantees, such as freedom of speech, rights of privacy, unreasonable search and seizure, and vagueness, also establish parameters on a board's authority. The Kansas legislature retains control over certain aspects of a licensing board, such as modifying the enabling legislation, which would change the purpose of the board, limit expenditures on an appropriations bill, and enact new legislation to change the makeup, scope, or powers of the board. In order to carry out the purpose, a board is granted or delegated powers and functions that parallel the three branches of government: executive, judicial, and legislative. Under the executive authority, the board carries out its enabling act and follows both the Kansas Open Meetings Act, or KOMA, and the Kansas Open Records Act, of KORA. In terms of the judicial authority, the board has quasi-judicial hearings in reviewing facts when violations of law have occurred, and also follows the Kansas Administrative Procedures Act, or CAPA, when appropriate. Under the legislative authority or administrative authority, the board adopts regulations to implement or interpret the enabling act with more detailed or specific requirements. This process involves holding an open hearing on proposed regulation, allowing feedback, and there is oversight by a legislative committee. In terms of the statutes, regulations, and policies, in order to fulfill its responsibility to protect the public from incompetent, unprofessional, and unauthorized practitioners, a regulatory board implements and enforces statutes and regulations, and at times operates according to internal policies. In order to be effective, board members need to understand the differences between statutes, regulations, and policies. First, statutes are laws passed by Kansas legislature through authority derived from the Kansas Constitution and subsequently signed by the governor. Statutes generally become effective on July 1st of that session year, but can become effective if a different date is specified in the legislation. Statutes set the parameters of the board's authority. And under statutes control any inconsistent regulation or policy. If a board becomes dissatisfied with the scope of the authority, for example, a board determines that it needs more investigative subpoena authority, the board can or must seek legislation to obtain its goal. Under regulations, regulations on the other hand are adopted by a board to further implement or carry out the purpose of a particular statute. The board's authority to adopt regulations is derived from the statute. In adopting rules and regulations, a board follows the Rules and Regulations Filing Act to ensure the process of adopting regulations is open, receptive to the public, and legislative input, addresses the economic impact of board and those affected, and the regulations themselves are consistent in style, organization, and grammar, are lawful, and are filed and published. Also for regulations are promulgated to complete or fill in details of a statutory scheme, implementing statutes, and affect rights and responsibilities of third parties outside of the board. And when adopted in accordance with the Rules and Regulations Filing Act, regulations have the force and effect of law. They are legally enforceable. To be valid, a regulation must be within the statutory authority conferred upon the board, implement a specific statute, and otherwise pass the test for legality. Any regulation that goes beyond the authority granted violates an enabling statute or is inconsistent with the statutory power of the board, another statute, or the Constitution will be found void. Concerning policies, policies may be adopted by a board only to guide its internal operations, such as prioritizing staff workload or explaining the investigative process. Guidance documents are documents that state a board's current approach to or interpretation of law, or general statements of policy that describe how and when the board will exercise discretionary functions. Concerning your effectiveness as a board member or advisory committee member, it's important to read the board's enabling statutes. Those are found on the BSRB website. They begin with KSA 74-7501. It's also recommended that you read the board's licensing act for your profession, and that's on the board's website. we have the statutes and regulations divided out by profession, so you can see which ones relate to the Marriage and Family Therapy Advisory Committee or the profession. You can also read the regulations for each licensing act, so separate from the statutes, they're the regulations. And then read the BSRB policies that are posted to the BSRB website, and those are linked under the resources tab on our website. It is recommended that you be on alert for agency policies and internal procedures which may be inconsistent with or conflict with the board's statutes or regulations, or which affect requirements for applicants or licensees. And be willing to initiate action to amend statutes or modify regulations. So for your purpose as advisory committee members, if you're reviewing those documents and you see items, feel free to reach out and we can have a conversation about those. And if there is something that needs to be changed, we can take action to do that by recommending to the board, they review that, or if it's just an internal policy that needs an edit, that may be something that we can accomplish without it needing the full board's approval. If a statute or regulation seems confusing or vague, it could appear that way to individuals who must comply with them. Remember, the purpose of imposing discipline against licensees is to encourage compliance with the law and protect the public. Discipline should not be vindictive or disproportionate to the severity of the violation. Always be mindful that the role of the board and the advisory committee is to protect the public and not the licensee. Concerning conflicts of interest, conflicts of interest typically mean having any interest, financial or otherwise, direct or indirect, or engaging in any business or transaction or professional activity, or occurring any obligation of any nature which is in substantial conflict with the proper discharge of the board member's duties in the public interest. Board members and advisory committee members must make public and recuse themselves from any conflict of interest that exists to ensure the integrity of the board and all its decisions. Disclosure and recusal are important tools to avoid actual or perceived conflict of interest, but board members must not overuse recusal as an excuse to avoid conflict and exercising their full responsibility. Some types of potential conflicts. Personal conflicts are those actions that may ultimately have a personal consequence that is a direct or indirect effect of a decision or action. No decisions should be made that will advance the personal benefit of the board member. Some other types of conflicts concern examples of personal conflicts could be items that would involve personal gain, bias, or effect on a personal relationship. At all times, a board member or advisory committee member must conform to the rules of confidentiality in dealings outside the boardroom. Protected information obtained in the capacity of board membership must remain confidential during and after board membership. Termination of membership does not dissolve the board member from their responsibilities. The rules that applied during active board membership continue to apply after termination of board membership. Confidentiality must be maintained on all confidential subjects that the individual was privy to as a board member. Some example of times when confidential information could be discussed. So if you are in an executive session, which occurs during an open meeting, if you go to an open meeting and then you have an executive session, then you can talk about confidential information within that executive session. Or also, if you are a board member serving as on a hearing panel, confidential information could be discussed in a closed session, such as deliberations after a hearing. The Kansas Open Meeting Act, or KOMA, and the Kansas Administrative Procedures Act allow the board to deliberate in private in order to reach a decision in a particular pending case. A note about professional activities. So a board member may hold an office in a profession or trade association with a regulated profession, but may not lobby for or cast votes regarding a matter that would impact the professional association or the board member's office in that association. The board member may not use his or her position on the board to further the interest of the professional association or his or her office in that association. Board members may attend professional conferences and social events, but they must be mindful of open meeting rules and conflicts of interest. If the majority of board members are present, do not discuss the business or affairs of the board to avoid triggering a meeting under the KOMA. Additionally, do not discuss matters related to a particular pending application or disciplinary matter. A board member should not represent himself or herself as a spokesperson for the board unless authorized by vote of the board to speak on the board's behalf. If a board member is asked to give the board's position on an issue and the board has not authorized that person to do so, the board member must decline to comment or make clear that any opinions expressed are those of him or her alone and not the board. The board member should not ask board member staff or board counsel to provide legal advice or preferential treatment to any applicant or licensee. Now we're going to shift to the Kansas Open Meetings Act, or COMA. So the COMA allows the public to observe governmental entities making decisions. Meetings shall be open to the public because, according to the statute, a representative government is dependent upon an informed electorate. Because the purpose of COMA is to benefit the public, it is interpreted liberally and exceptions are applied narrowly to carry out its purpose. The COMA applies to all legislative and administrative bodies and agencies of the state and other subordinate groups receiving or expending and supported in whole or in part by public funds. The COMA does not define the term subordinate group, but if created by a covered entity or the group has become an extension of the covered entity, most likely the subordinate group is the subject to COMA. So basically the advisory committees would fall under COMA for that purpose. The COMA does not apply to an otherwise covered entity when exercising quasi-judicial functions or conducting a proceeding or hearing under the Kansas Administrative Procedures Act. COMA also does not apply to the judiciary, private organizations, or staff meetings of a covered entity. A meeting is defined as any gathering or assembly in person through the use of a telephone or any other medium for interactive communication. Item 2, by a majority of the membership of an agency or public body subject to the act, or 3, for the purpose of discussing the business or affairs of the public body or agency. And it's really important to understand that for something to be constituted to constitute a meeting under the COMA, you have to have all 3 of these present. So for something to be considered a meeting, it does have to be a gathering or assembly, but that can be in person through the use of a telephone or other medium of interactive communication. There has to be a majority of the members of that body, and then has to be for the purpose of discussing the business or affairs of the public body or agency. Meetings may be conducted by telephone or other electronic mediums such as Zoom or Skype or Teams if the board complies with all COMA requirements. A Teams meeting or a meeting includes informal discussions before, after the public meeting, or during a recess of a public meeting, and all gathering at all stages of the decision-making process. The name of this gathering is irrelevant. Thus, if you call something a work session or a retreat, those could still be public meetings and subject to the COMA. A discussion does not require binding action or voting. A discussion can occur at social gatherings, retreats, and meetings held in private. Educational conferences or seminars. Thus, when traveling to such meetings, members of the board should avoid discussing business or affairs of the agency if there's a majority of members present at that time. Also under the COMA, the presiding officer has the duty to provide notice of the meeting, but this duty may be delegated. The COMA does not require notice of meetings to be published in a paper or on a website. An individual must request notice of meetings. There are no formalities for requesting notice that can be done verbally or written. And just to let you know, we take care of the open meetings notices on behalf of the agency. So we do send out an email to all individuals who have requested notice of meetings. We also post on a website called the Kansas Public Square. So that we provide notice of upcoming meetings on that website. And then on the BSRB website itself, we post the information about upcoming meetings and also materials for that meeting. The notice must provide the date, time, and location where the body will meet to the person requesting the notice in a reasonable time before the meeting. A request is valid for 1 fiscal year. The board must notify a requester of expiration before terminating notice to that requester. The COMA does not address meeting procedures, so a board is not required to follow Robert's Rules of Order, for example, or any other similar formal rules of procedure. The COMA does not require a board to create an agenda, but if one exists, it must be made available to everyone. A person may record the meeting if doing so is not disruptive. The public does not have the right to speak, but only to listen and observe. The board cannot vote by secret ballot. A board policy may require minutes to be kept, but the COMA does not require the board to have minutes unless there is a motion to go into executive session. The motion as made must be included in the minutes. An executive session permits discussion of certain enumerated matters outside the public view. To take an executive session, the board must first convene an open meeting. The board cannot take binding action in an executive session, but a consensus is allowed. If a consensus is achieved, the board must reconvene the open meeting and take a formal vote in an open session. If there are any issues about COMA, prosecutions are civil, not criminal, and any person, county district attorney, or the attorney general may bring an action in district court. The county or district attorney and attorney general have subpoena power, and enforcement actions take precedence over all their cases and are assigned for trial at the earliest practicable date. The remedies for a COMA violation include voiding an action taken if prosecuted by the Attorney General or County District Attorney, an injunction, stopping an action, a mandamus, forcing an action, or a declaratory judgment. And the penalties for a COMA violation include a fine up to $500 per member, not the board, for each violation, ouster from office, recall from office, court costs assessed to the person seeking enforcement of COMA, court costs assessed against the plaintiff if maintained action frivolously, not in good faith, or without reasonable basis in fact or law. So before we move on to the Kansas Open Records Act, I do just want to state that we take COMA very seriously. Whenever we do have meetings, we make sure we get the announcements out to those individuals in the format that we talked about. We also provide the notice at the beginning of the meeting, so individuals have some additional notice if they want materials for the documents, or they want the agenda. So we will be mindful and make sure we're taking care of all of our responsibilities on your behalf and also the board's behalf in terms of COMA. Also, in terms of the meeting requirement, it is important to stress that again. Those meetings that we need to be cautious of can be in person, but they can also be electronic. And that's part of the reason why we can't have discussions between advisory committee members if we have all the advisory committee members or a majority of them on the same email chain. And so we can't have members discussing items back and forth to kind of work on things ahead of time. Now, it's okay if you have just a member or two, as long as you don't have a majority of members, that's okay. So you can talk to each other outside of meetings. There's nothing forbidding that. It's just when it becomes the majority of members and there is discussions back and forth about the affairs of the agency or the advisory committee, that's when you would fall into an issue with the Kansas Open Meetings Act. So if you do have questions about that topic, feel free to reach out. I'm happy to clarify any of that for you. In terms of the Kansas Open Records Act, or the KORA, there's also a statute that requires the board to have its records open for inspection by any person unless otherwise provided, and KORA shall be liberally construed and applied to promote such policy. Public agency includes the state or any political or taxing subdivision of the state or any office, officer, etc. The thing to take away from this is that the Kansas Open Records Act does apply to board members, BSRB staff, and it also applies to you as advisory committee members in terms of your records as they relate to the advisory committee. So if created by a covered entity or the group has become an extension of a covered entity, it will most likely be covered. So as I said, the board is covered, but also advisory committees are covered under KORA. And there's a little bit of more of an explanation about covered entities that's described in law. A public record includes any recorded information regarding a form or characteristics which are made, maintained, or kept by or in the possession of any public agency, and written records, photographs, computer data, and email. Public record does not include records that are owned by a private person or entity and are not related to function, activities, programs, or operations funded by public funds, or records not in existence at the time of the request. The board is not required to create a record in order to fulfill a request. Under KORA, the board must appoint a Freedom of Information officer to assist with KORA requests. We have done that, and Leslie Allen serves as the appointee for that. We must display, distribute, or otherwise make available a brochure describing a requested right, agency responsibilities, and procedures for inspecting and obtaining copies of public records. And we have that posted here in our office. And that document must also include the name and title of a records custodian, fees, and office hours available for anyone to make a request. And that is included in that document as well. In Kansas, any person may make a KORA request. The person need not be a resident or provide a reason for their request. And the board may require the request to be in writing, state the name and address of the requester, provide proof of identification, and sign a written certification the requester will not use names and addresses obtained for the records to solicit sales or services. Unless closed by law, the board cannot deny a person the right to review its public records. For instance, copyrighted materials may not be reproduced without the permission of the copyright holder, but must be made available for viewing or listening. If portions of a record are closed, the remainder of the record must be made available to the requester. This is referred to as redacting. And the board is not required to make copies of a recording of a tape or disc, videotapes or films, pictures, slides, or graphic illustrations, unless shown at a public meeting. In terms of our responsibility for KORA requests, the request must be acted upon as soon as possible, but not later than the third business day following the date the request was received by the board. And 3 responses are acceptable. 1, the record is provided in the form requested if possible. The request is under review and the records if permitted by law will follow. And then the request is denied with a detailed explanation of the denial. So based on this requirement, We do not have to provide all requested records in 3 days, but we do need to provide a response to those core requests. And on behalf of the agency, we take care of those types of core requests. Under core, there's a presumption of openness. As such, the requested public records must be released unless an exemption to disclosure applies. The burden rests on the board to prove the requested records are exempt from disclosure. Exemptions to disclosure may be discretionary or mandatory. And then similar to what we talked about with COMA, if there is a violation, it's a civil, not a criminal act, and then it talks about certain people who can bring those actions. Further, the records talk about the penalties and fines for any violation of the COMA or the CORA. And they can be imposed if the board's denial is not made in good faith and without a reasonable basis in facts or law. And so on behalf of the agency, we take care of CORA requests. We do have a Freedom of Information Officer here. And then if there is a question about what can be provided or what needs to be redacted, we consult with legal counsel. If you do happen to get a CORA request that has to do with any of your dealings with the BSRB, please let us know at the earliest possible convenience so we can help you with that response letter. And then also we can check to see what information needs to be provided. In terms of messages, I think it's always helpful to give everyone a reminder. You're all professionals, but sometimes when people think of records, they think of formal documents that say this is the record, etc. However, under the CORA, there's a lot of informal communications that if they are recorded, they could also constitute a record under CORA. So just be mindful that things like text messages or emails, so those could fall under a CORA request. So when you're talking about something, please be mindful to always make sure you use professional language. And I'm sure that's not something you need a reminder about, but I feel like it's helpful just to get a quick message on that point. And then we're getting close to the end of training, but let's talk a little bit about the Kansas Administrative Procedures Act, or the CAPA. It creates procedural rights and imposes only procedural duties. The CAPA does not provide substantive law. Those laws are governed by the Board's Enabling Act and Licensing Act, and the CAPA applies only to the extent that other statutes expressly provide for the provisions of the CAPA that govern these provisions. The general rule is that licensing boards like the BSRB must do business in an open meeting under the COMA unless directed by statute to conduct the proceedings or hearings pursuant to the CAPA. And those two acts are mutually exclusive. So when our statutes provide that the CAPA will apply certain decisions, the board will follow CAPA, not the COMA, when making those decisions. And the CAPA sets out a procedure to follow when the board is deciding what to do in cases involving individual licensees, much like the procedure that is followed in court cases. In those types of cases, the board is conducting a quasi-judicial function and deciding the outcome of a case. When the CAPA applies, none of the stages of a particular case has to be open to the public observation other than a hearing itself. Each of the board's licensing acts have a CAPA provision, and under the CAPA, neither the public nor an applicant has to be notified when the board meets to consider an application for licensure. Similar, under the CAPA, neither the public nor the licensee has to be notified when the Complaint Review Committee meets to consider whether probable cause exists in a disciplinary case or issue a summary proceeding order. Additionally, the board and the CRC do not need to take a vote in public for decisions made under the CAPA. Under the CAPA, decisions are made when the license or an order is issued. The necessary board staff and board or CRC's attorney can be present during the CAPA discussion to make sure the board members have the information or legal advice they need to make an informed decision. And there are some board activities that are not covered by the CAPA, and these must be acted on in an open meeting under the COMA. These include approving board minutes, discussing and voting to approve or amend regulations or guidance documents, delegating authority to a board member or to the executive director for a particular action, receiving agency updates, updates related to the budget, legislation, statistics on complaints and CRC activity, education, and the executive director's report, decisions whether to renew contracts or change the way contracted services are provided, and policy decisions affecting the way the board operates internally. Concerning applications for licensure, when someone files an application for licensure, they have the burden of proof, and staff will gather the information submitted by an applicant for the board's consideration in determining whether the applicant is qualified for licensure or whether a license may be conditioned or restricted. If the board denies, conditions, or restricts a license, an applicant may request a hearing if the applicant did not agree to such action in a consent agreement and order. And then under our investigations, the board has the burden of proof to show a licensee has violated a statute or regulation, and all licensing boards can investigate complaints or allegations that a licensee has violated a statute or regulations. The board's investigator generally gathers information and then presents that information to the Complaint Review Committee. The CRC reviews the information to determine whether there's probable cause or reasonable grounds to believe that a licensee has violated specific statutes or regulations. Reasonable grounds means information that would lead to a reasonable, prudent person to believe the licensee violated one of the board's statutes or regulations. When making the determination, the CRC must make sure the conduct the licensee is accused of actually violates one of the board's statutes or regulations. The fact that the licensee did something that made someone angry, violated a professional association's ethical code, or did not follow an employer policy does not necessarily mean the licensee violated a statute or a regulation. The licensee can request a hearing on the summary proceeding order within a certain prescribed period of time. Once a petition or request for a hearing is filed, the CAPA guides the proceedings and the hearing. If there's an immediate danger to public health, safety, or welfare, the CRC may suspend a license without giving the licensee notice and an opportunity for hearing, but the licensee can appeal an emergency order to district court. And then the last item I'll mention on here has to do with the Kansas Tort Claims Act. So in general, the Tort Claims Act governs the liability of the state of Kansas and its agencies and employee. An employee includes a member of a board or committee of a governmental entity, including elected or appointed officials and persons acting on or on behalf of the service of a governmental entity in any official capacity, whether with or without compensation. And there is an attorney general position on this topic, whether advisory committees sit under the Kansas Tort Claims Act. And the opinion that is on our website does show that the attorney general's opinion is that advisory committee members are covered by this act if they need to be. The basic rule of the Tort Claims Act is that vicarious liability for any actionable wrongful act or omission of government employees within the course and scope of their employment, subject to affirmative grants of immunity that may exist on a case-by-case basis. If you are sued for an act that occurs within your scope of your duties as a board member or as an advisory committee member, you are entitled to have the state of Kansas defend you at no cost. But there are certain requirements that must be fulfilled for this to take place. So to obtain representation by the state, you must submit a written request within 15 days of the service of process and cooperate in your defense. And the state may choose not to defend you if you acted with actual fraud or malice or failed to make a timely request for representation. And the general rule is that the state will pay for any judgment rendered against you unless the judgment is for an act or omission that occurred outside your scope of your duties as a board member or advisory committee member, you failed to cooperate in your defense, or you acted with actual fraud or malice. And so we hope this never comes up. It has not come up since I have been with the board. But if you do get any notice that you are being sued for whatever reason because of your membership on the board or advisory committee, please notify me at the earliest convenience, and then I will get in touch with our legal counsel and make sure that we're doing what we need to. Like I said, it has not come up. I hope it never does, but I think it's important for you to have this information ahead of time. So I realize it's a lot of information. You probably need some time to digest that. It is posted on the BSRB website, so you can go back and look at some of this material. But if you ever have questions, feel free to reach out to me. There are certain rules we need to be mindful of, but there's a lot of flexibility in our interactions with each other. And so the items that are really important that members do have a little bit of questions about, I tried to stress. But if you do have any questions, feel free to send me an email and we can either communicate that way or figure out a time to talk a little bit more in depth.
Thanks, Dave. A lot of information. Are there any questions or comments for Dave? I know it's a lot to get through. Okay, well, just real quickly, we left on the agenda then 2 old business items, but I feel I'm going to check in on one of them, but I think I feel pretty confident going into the board meeting retreat on where this advisory committee stands. We had talked about the other professions serving as supervisors for marriage and family therapists, and I think I understood this group pretty clearly that we feel our profession is separate and distinct and needs to be supervised with systems thinking in mind. So I think I felt pretty good about that. And then we had a great robust discussion about clinical training plans changes. And as Dave mentioned, that board will take that up also in the retreat coming up. And so I feel like I can represent our opinions pretty well on that. We would like to have some discussion about meeting dates for 2024. Simply, we've been meeting on the second Friday of each month from 10 to noon and just checking in to see if the majority of the year we feel like that's a good still a good schedule for everyone. Okay, we'll plan on that. And then again, there are some months where maybe variances might occur and we can always come up with an alternate schedule. So speaking of, on December 8th would be our next meeting, tentative meeting date. And I do have a conflict that'll take me out of town. And I also have a conflict on the 2 Fridays, the Friday before and the Friday after. So Dave and I talked this week to see if there would be some flexibility on a different day in December. We probably will have quite a bit of follow-up from the board meeting retreat. So it would be a good and important meeting that we'll have things to share, but also probably some decisions to make. So Dave, remind me, we looked at, I think there was a Tuesday. Can you remind me of those dates we were kind of looking at and see if we could get a majority of the people?
Sure. So during the week of December 4th, so we have flexibility here at the office anytime on Tuesday, December 5th, and anytime on Wednesday, or at least, yeah, but basically anytime on Wednesday, December 6th, or Thursday, December 7th. And if any of those days don't work, there is some more flexibility on the following week, December 11th. I believe that Tuesday, Wednesday, and Thursday as well.
Yeah, for my schedule, I'd probably need to go into the week of the 11th. I know it gets tight around December's for everyone, but are there dates on the 11th, 12th, or 13th that would, the 14th?
I could do the 12th. I would just need to be done by 1.
So a 10 to noon on the 12th.
That would work for me.
Does that work for everyone else?
That would work for me.
Oh my gosh, Nicole?
I mean, I can for sure do 10 to 11, and then I can see if my 11 o'clock can maybe be moved. But I can at least do the half of it.
Well, that's better than I expected. So thank you for flexibility. I know how hard it is with everyone's schedule. So we will plan on we're at Tuesday, the 12th from 10 to noon.
Yes, thank you, Mary, because that 8th, the Friday, was not going to work for me either.
Okay.
So this will be, thank you.
Well, I'm just glad we were able to find, it looks like a date, and hopefully Nicole, you'll be able to join us for the whole time at that point. But if not, we'll be glad to have you for the 1 hour.
Just to confirm, we're canceling the 8th and meeting on the 12th.
Yes.
Okay.
And David will send an updated invite, I'm sure today. He'll take care of that, but we'll get that on your schedule. So thank you for that.
Yeah. And what I will do for those of you, you already have a calendar appointment with the information for the meeting that was going to be on the 8th. So I will just change that announcement, and then I will go ahead and start sending out some calendar appointments for the date during calendar year 2024, which would normally be on the second Friday of the month, on those months that they have meetings from 10 a.m. until noon. So.
Okay. Any other business for today? As a reminder, if you all think of topics or if there's something you want us to get on the agenda, you are welcome to submit agenda items to myself or Dave, and we'll make sure to get those for each of the meetings. Whatever's going on in your areas might be important for us to talk about as an advisory committee, so please feel free to do that. Well, if there is no other business, then I will accept a motion to adjourn.
So moved.
Thank you, Journey. In a second. Thanks.
I said it. Oh.
All right. No, you're good. You're good. Okay, everyone, have a wonderful weekend. It's great to see you. Thank you for your participation today.
Have a great weekend.
Thanks,
Bye.
everyone.